Are you done?
Yes, Judge, one last point.
I thought you were done.
I was until you made that comment.
Sir, I might suggest that you get yourself an attorney to represent you. I've let you go on far longer than I would normally let anybody else go on regarding this. Glenco Hills versus Angela Stoker. Hello. What's your name? All right. And how much is owing on this?
$870.06.
All right, you know the question. When do you think you can get this paid?
How approved date?
Eight. Eight.
Yeah, they said 3 days ago. Yeah, 7 days. I see that, Your Honor.
They have approved, so everything but 50 is approved, is that the deal?
That's the late. They just put that on there yesterday.
All right. They can't waive that late fee if it's been approved. Okay, well, here's what I'm gonna do. I'll adjourn this out. Well, when did they say that? Do you have that the check was released or you don't know?
Yes, Your Honor. We received it today from Ms. Sykes today, stating that a check for $820.06 was mailed on April 9th.
Okay, so here's what I'll do. Let me adjourn this then to April 25th, 2025, 12 noon. If that $50 is still there, then come back and then I'll have to make the decision on the 50. All right. Fair enough.
Yeah.
All right, take care. Golfside Lakes versus Patrice Haywood. Right. Where are we on her case?
Legal services contacted me, indicated that there is a commitment letter that's issued for that full amount.
Oh, okay. So why don't I put it over to the 25th, 2025 at 12 noon? Okay. How are you doing otherwise? You're okay? All right. Keep smiling. Have a great weekend. Hamilton Crossing 1 versus Crystal Stanley. Crystal Stanley? They did not check in. If you wish to take a default, raise your right hand.
No, I don't believe this is
You want to know what? Hold on. This might be the same thing. No. It's a writ hearing. It was no writ without a hearing, correct? Has the 392 been paid? Well, I had, when the writ was submitted, that 174 of the 392 had been paid.
Yes.
And did they finish the balance? Please say yes.
No, I don't see that anything else has been paid. Can we pass this one out?
All right, yeah. Pass it. Court calls case of Hamilton Crossing 2 versus Tiffany Roots. Tiffany Roots?
Yes, I'm here.
Oh, there you are. Okay. Okay, how much is owing on this case?
$2,081.
$2,081.
I'm sorry?
All
No.
right. Pardon?
No. I have a receipt right here that shows I owe $760. Where did the 2,000 come from?
Hold on.
So April rent was added.
April rent got added to your ledger, man.
Okay, April rent has been paid. I have a receipt with today's date on it that shows 760.
Okay, so hold on. Did you make a payment today?
Yes.
Okay, you can hold that up all you want. My eyes, I can't pick that up. All right. So,
Yes.
all right, then let me do this. So how much do you owe now? You, according to your thing, your receipt?
$760.
Okay, so if I work off of that figure, when can you get that paid?
Okay, so that was it was only left behind and unpaid because of the approval from Department of Human Services. There was
Okay.
that they were supposed to pay it, but there was an error made. So I have an appointment to come up there and speak to my worker today to find out what the holdup is for them to pay the final amount. I do have that amount set to the side so that I can, if they are not going to cover it,
If
then
they're not gonna do anything. All
Yeah.
right, so let me do this then. I'll adjourn it out a week.
okay.
Let you try to figure that out and let's see where we are, okay? Fair
Okay.
enough?
Yes, not a problem.
One detail that
April-
is easy to miss here is that Judge Simpson isn't deciding who is right based solely on the numbers being recited in court. He's first trying to determine whether the debt itself is accurately calculated. When Tiffany immediately challenges the landlord's balance and produces a receipt showing a much lower amount, the focus shifts from enforcement to verification. In landlord-tenant court, an updated ledger can dramatically change the posture of the case, especially when recent payments or assistance programs haven't yet been reflected. Notice how the judge asks practical questions instead of making assumptions. Rather than treating conflicting figures as proof that either side is being dishonest, he creates time for the records to catch up. That's a procedural safeguard, not favoritism. Her explanation involving the Department of Human Services also matters because it offers a reason for the remaining balance without denying responsibility altogether. Do you think producing documentation this quickly strengthened her credibility? And would the outcome have been different if she had arrived with only verbal explanations instead of receipts and a clear payment plan?
April 18, 2025, 3 p.m.
Okay. Thank you.
Okay?
Yes, thank you.
Thank you. Have a great weekend.
You too.
And then Hamilton Crossing 2 versus Sunji Sprites. That matter is, oh, you're here. I didn't know you had been sitting there waiting. They have moved to dismiss your case.
Right, because I got an email.
Okay, well, so your case is dismissed. All right, thank you for coming down. Okay, you have a great,
Copies of.
the dismissal? You waited all this time. I don't usually do this. I'll get you a copy. All right? Okay, you take care. Have a great weekend. On the other one, okay. Dizak Enterprises, AKA Motel Manor versus Malcolm Hanks. And Alyssa Robbins, I'm sorry.
That's okay. John Mitchell, on behalf of the plaintiff, my right is Casey Zach, who is representative from the plaintiff. I've not received a response, and the defendants are no-show. They didn't show the first hearing.
All right.
This is a non-payment rent case.
Raise your right hand to be sworn. You solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God. All right, how much is owing?
How much is currently owed?
$7,760.
$7,000.
Oh, sorry. Oh, it's, court fees, $7,971.40.
Let me break that down, Your Honor. It's $11.40. Court costs $7,760 for rent to retain for a total of $7,970.
All right.
Court.
Judgment to the plaintiff, that is by default for possession, redemption amount is in the amount requested with the writ to issue in 10 days. And I have signed your judgment.
Thank you, Your Honor.
All right, thank you.
Thank you.
Court calls the case of Arbor House Apartments versus Jasmine Branch.
Good afternoon, Your Honor. Mark Land on behalf of the plaintiff.
Your name? All right. And how much is owing on this?
$9,341.24 in rent, $180 in court costs, total of $9,521.24.
Well, they probably, from the last time, they would have added April rent in. And you have not received a $2,000 check yet. Is that right?
No, that's correct, Your Honor. Your Honor mentioned that at the previous hearing, that $2,000 was paid into escrow. It was being released to the plaintiff. You didn't need an order from me to have that released.
Correct. It's been
probably-
released, but it
Very
didn't get
good.
released until the 8th. So,
Very good.
Been trying to contact me for like weeks now. Like I just got an email from her today. She said nobody's been answering the phone, so they can't.
nobody at Hawk
No, nobody.
has your client been responding to Hawk?
Yes, Your Honor.
Okay, because she's got an email saying
I just got it again. She said that they haven't been answering emails.
they haven't been answering emails or calls.
Hawk is welcome to contact me, but I did reach out to my clients after the last hearing to ask if she had gotten any contact from Hawk. And trying to pull up that email now.
Her name is Kathleen. Kathleen?
Kathleen.
Yeah, I was
Sorry,
just
I'm not
talking to her
seeing,
at
I'm not
1:20.
finding that email, Judge. I'm sorry.
All right, here's what we're gonna do. Ma'am, we're gonna give you Mr. Landau's email, and we're gonna need you to forward that, if you would, to him. I'll adjourn this out 1 week to the 18th, and let's see where we are.
Okay, thank you.
2025, April 18th, 2025 at
1 p.m.
1 p.m.
Judge,
Okay.
one other matter. My
Sure.
notes indicate that Miss Branch indicated that she would be paying $1,500 out of her own pocket by April 4.
That is true.
That has not been received. I'd like to find out what the
I won't
status
get
is.
it until next week. In fact, I just started another job. So
You won't have it until the
the
14th.
next time,
I'm sorry,
the next court date I'll have.
the
I'm trying to
18th
have the whole-
by that time?
Yes.
Okay. All right. So she didn't get it by the 4th. It's a paycheck, right? So it's the 18th that she'll get it. So she should have it on the date that she comes back.
Yes.
Okay.
So I'm gonna have to
Very
try to
good.
have the whole 28. And then I'll
Okay.
have to work on this.
I will look for Miss Branch's email over the next 3 or 4
Do you
days.
have a-
Yeah, hold on. We're gonna give it to you. Okay? Thank you. Court does call the case of Westborne Family Trust versus Daryl West.
Mark Lando on behalf of plaintiff.
Mr. West, state your appearance. Just state your name. You gotta unmute first, sir.
Earl West present.
Okay, where are we on this case? I'm afraid to ask.
Judge, this is a termination of tenancy action. My client is the owner of property. Mr. West is the trustee and the trustee's brother. He's been living there a lot of years, and they are estranged. And my client just wants to get the property back, sell it, and that's pretty much the long and short of it.
It's not the long and short of
All
it.
right, well, I've read everything that you submitted, Mr. West, much of it irrelevant to these proceedings, quite frankly. The only thing that I have that may be of some relevance, is there a matter pending in the Court of Appeals?
Absolutely. Case number 375000.
There is, Your Honor,
375.
Mr. West filed a motion to stay the eviction case that was denied.
That's not
Oh, in the
exactly
Court of
correct.
Appeals?
It was denied with the Court of Appeals.
All right, thank you.
Judge, that's not exactly correct. It's a misleading statement. Actually, what happened was filed an interlocutory appeal, and the circuit court went ahead and ruled while that interlocutory appeal was pending. Therefore, I filed a right of appeal and let the interlocutory appeal be dismissed. And it was on that basis that the interlocutory appeal was dismissed based on the current pending case. And there's still on the docket a motion.
But there is no stay of these proceedings.
There is a motion for stay of these proceedings on the 375000 case.
All right, well, you're gonna have to get to them because I don't see here that I've got a tribal issue. I am not gonna stay these proceedings. And so if the Court of Appeals wishes to stay it, then the Court of Appeals can stay it. Mr. Landau has indicated that they denied it. You're indicating something different.
Am I
than
entitled to
that.
a jury trial?
If I don't have a tribal issue, no, sir.
Judge, there's promissory estoppel, there's quantum meute, there's a written documented contract documented and subscribed by the plaintiff.
All of those are not tribal issues that grant you possession of the premises, sir.
The document subscribed by the plaintiff grants me premises occupancy.
I disagree. It's not a tribal issue for me, sir. You show me nothing that gives you claim to those premises.
I submitted the document where the owner of the property granted me living arrangements to the property. That's in the file.
For how long, sir?
For the balance of my life.
I do not see anything in here representing a life estate. If you are claiming that you have a life estate, then you need to file the appropriate paperwork.
It's
in
not a life
circuit
estate,
court.
Judge.
This
You
is the
need to
legal turning point of the hearing. Mr. West continues raising issues about prior litigation, alleged inaccuracies in the complaint, property maintenance, and appellate proceedings, but Judge Simpson repeatedly redirects the discussion to one central question. Is there a legally recognizable defense to possession before this court? That's an important distinction. Courts are limited by jurisdiction, and a defendant can lose credibility when arguing issues that, even if true, do not legally resolve the question the judge has been asked to decide. The claimed lifetime right to occupy the property is potentially significant, but only if supported through the proper legal vehicle. Judge Simpson makes it clear that he does not see documentation establishing a life estate in the eviction record before him. Instead of deciding ownership rights, he explains that such claims belong in another proceeding capable of determining them. Did you notice how the judge becomes increasingly focused on relevance rather than volume? Lengthy arguments often feel persuasive, but courts evaluate whether those arguments address the legal issue actually before them. In litigation, presenting the right evidence in the right forum frequently matters more than presenting more arguments.
You need to file the appropriate paperwork in the circuit court so the circuit court can make a determination as to whether or not you have a life estate of some type on the premises. But I do not see that. I do not see any defect in the notice which has been provided by the plaintiff in this case. I have nothing to try.
Please address their complaint. Their complaint clearly files misleading information. In item 2, counsel says there is no other pending or previously filed document or court actions. And in fact, there was a circuit court action and it's under appeal now. Therefore, that's misleading statement. Furthermore, in
Which has no relevance to this court and its decision. Because this case would not have gone up to circuit court.
this case was already in the circuit court on a parallel.
No, sir. This case is a district court case. This case, regardless of what plaintiff said, would have been filed and resided right here before me.
Judge, can I go on further to the complaint?
Not if you're going to waste my time.
I'm not. In
Yes, you
section
are,
8
but go ahead.
In section 8, plaintiff and counsel suggest to this court that the property owner has maintained that property in accordance with state law as it's a residential unit. That is absolutely a false statement. She has stated in a statement of facts and a motion at the circuit court that she hasn't communicated or been in contact with the resident occupant, Daryl West, in 10 years. She has not maintained the property in accordance with Michigan law. Furthermore, because I had to maintain it, I spent $25,000 of my money to keep the property maintained. She has completely falsified the complaint, Judge. She did not provide adequate maintenance to the home in reference to Section H of the complaint. That's a false statement. There's 2 false statements provided in the complaint, and the court should order a show cause hearing at the very least and should actually dismiss this case.
Are you done?
Yes.
It still is not an issue related to the termination case. If you believe that there's a money case that needs to be filed, then you may do so.
Judge, one last point.
I thought you were done.
I was until you made that comment.
Sir, I might suggest that you get yourself an attorney to represent you.
Can you adjourn it?
Because the
while I
termination
do?
case, nothing has been filed before me that gives me anything to try as a reference to termination case. I'm going to keep saying it. There's nothing that you're saying to me right now. I've let you go on far longer than I would normally let anybody else go on regarding this. If you have one more thing to say to me, you may, and then I'm going to have my word.
Have your word, Judge.
Court finds that there's no tribal issue as to the issue of possession. In this matter, I will grant judgment to the plaintiff for possession with a writ issue in 10 days
Wow.
from the signing of the order.
Judge, as much as I appreciate the court making that ruling, I'm willing to give Mr. West additional time. My client is his sister, and even though they're estranged, she knows that this is going to create a hardship for him. He is an amputee, and it's going to take him some time to vacate. I want to give him the comfort of some additional time.
So here's what I'm going to do, Mr. Landau. I understand that. So I'm going to issue my judgment. What the parties work out, you can work out. But I'm going to issue the judgment as I pronounced it.
Very good.
Thank you.
I'll submit the judgment.
Dow Trim and Julie Yasu versus William Dunlay. Hello. Hey, who do I have here?
Good afternoon, William Dunlay, Glenco Trim, and I'm Defendants.
Okay. All right. Where are we on this case, folks?
Bill has moved out of the house.
Okay.
He's left it in good order. He's done a real nice job of cleaning up. He's not out of the garage yet and or the driveway. But you know, that's not a critical issue right today, because we're still paying the repair of the house and everything, the inside. So we're not. That's fine. And
He's out of the premises.
he's out of the house, but not the garage.
Got it. Okay. So what do you guys want me to do?
What we'd like to do is get a judgment ordered for what we.
Do the parties agree on how much is owed?
Yeah, I think so. At this point,
Then all you need to do is fill out a judgment form, submit it for me for signature, and I'll sign off on it. If you guys agree on the amount.
okay, it's 34, 900.
Do we have to submit that right?
34,000.
34.
My jurisdictional limit for the issuance of money judgment, 25.
That's what you told us the last time.
I know, and it still is.
And you said though that we would, you said you would work something out on the balance. Would be able to work something out on the balance.
I don't know that I can work anything out. All I can do is 25,000 plus cost.
no ifs, ands, or buts, I stipulate to at least that amount for sure. I mean, it's more than that, so I know that if that's what you can do, fine.
Well,
Okay.
we can stipulate,
I'll sign right now
we can stipulate to the 34,938, can we not? And
That stipulation, everybody wants to use legal words. I don't know that you guys agree on that. I cannot issue a judgment for that amount. I told you that before you came back here today.
Oh, the next question.
Sure. If you want me to send you to circuit court for it, I'm sure there's a judge up there that'd be more than happy to hear this.
Does it mean if the 25 were to happen, that it would mean that is it? If
That's it.
whatever and it's done, that they wouldn't have regret about the further amount. I don't necessarily want to do that to them. Or is that just
That's a legal question I can't answer as to what one's remedies might be. So what do you folks want me to do?
I have one question.
Yes.
Because last time probably I didn't fully understood what you said. At the end, you said the maximum you can do is 25,000. Then you can work something else for both. But I was wondering if it's possible, this 34,900 can be split into two
orders.
orders.
Yeah, that's what she's asking, two orders.
I understood what you said. You don't have to try to man speak it for me. I clearly understood what you said.
It's possible, but I don't.
I can't do that.
So, okay. I guess I don't quite understand if if I only, now is there any other way that I can get the full amount back?
Sure. You can file an action in circuit court, which would have jurisdiction to issue a judgment in excess of $25,000. Because possession is no longer an issue. So you could file a complaint in circuit court and the circuit court could issue that judgment.
So, I agree that today we sign us that 25,000. Can we do that later on top of that, we should the additional amount?
Say again?
So.
I'm not splitting two judgments. I'm not issuing two judgments.
I understand, you said if we want the full amount back.
Then you can take it to circuit court. All right, look, here's what I'm gonna do, because I've got other matters that I gotta deal with.
We're good with that.
I don't know what you're good with, because nobody has said anything.
The maximum.
The 25,000?
Yes.
Okay, and you agree with that? Okay, you guys need to fill out a judgment form. I'll enter the judgment for the 25,000 monetary judgment for that amount, for the $25,000. I need a judgment that I can sign. So you can go out to the front counter, get a judgment, fill it out, get it back to us, and I'll sign off on it.
Okay,
just bring that.
we,
How do we bring it back to you? That's all.
do we give it to her?
You can give it to the clerk's office. They'll be more than happy to take it for my
I
signature.
see. Not.
You don't have to come back.
I see, just give it to them.
Really, you don't have to come back.
Okay, my wife is asking, what about, in the order, can you enter what Bill agrees to pay back in terms of monthly?
Folks,
monthly.
square peg, round hole. I have $25,000 that I can do.
Oh, yeah.
I told you to do it.
Payment plan is what she's asking.
For the payment plan for the 25,000?
Yeah.
You can put that you can put that in the judgment form.
Okay, all right.
Whatever he's gonna pay per month or however he's gonna pay the 25.
Okay, last question, Your Honor. Is it possible that, even though we're maxed out at 25, can you mention in that order that the full amount that was owed was the 30?
Square peg, round hole. No,
Okay, I understand.
thank you.
All right, well, thank you for your time. We appreciate it.
Thank you.
This hearing illustrates that many landlord-tenant cases are decided less by emotion and more by procedure, documentation, and judicial discretion. Throughout the session, Judge Simpson consistently looked for verified payment records, current account balances, agency commitments, and legally relevant defenses before making decisions. When payment assistance appeared likely, he frequently granted short adjournments instead of rushing to judgment. That approach encourages compliance while preserving both parties' rights. By contrast, in the Westborne family trust case, the court concluded there was no factual issue requiring a trial on possession because the arguments presented did not establish a legally recognized defense within that proceeding. Whether other disputes existed elsewhere was not enough to prevent the court from deciding the eviction action before it. Meanwhile, in the final dispute over the $34,900 agreement, Judge Simpson emphasized another important legal principle. Courts cannot exceed the jurisdiction granted to them, even when every party wants a different result. Agreement between litigants cannot expand the court's statutory authority. The broader lesson is that successful courtroom advocacy depends on presenting evidence that directly answers the legal question the judge must resolve. Staying focused on jurisdiction, admissible proof, and the applicable law is often far more persuasive than broad or emotionally charged arguments. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.